What qualifies for family medical leave in Colorado? Colorado employees often face difficult decisions about balancing work hours against taking leave from work for illness, disability, and the care of family members. Legal protections exist for employees to take certain types of family leave and medical leave, but it can be tough to figure out when those legal protections exist. Colorado employees may struggle to figure out what qualifies for family medical leave in Colorado. Under federal and state employment law, family and medical leave include specific categories of leave that include serious medical conditions and to provide care for specific family members. Adding to the complications of federal and state FMLA laws are other related laws that provide different legal protections for family leave and medical leave. FMLA and Colorado FMLA. For most employees in Colorado, family medical leave is available through the federal FMLA and state Colorado FMLA. FMLA is the Family and Medical Leave Act. The federal FMLA protects the right for employees to take up to 12 weeks of unpaid leave from work for specific family and medical reasons. The Colorado FMLA expands upon the leave protections of the federal employment law to extend additional reasons to workers. Assessing leave rights under both the federal and Colorado employment law requires a multi-step analysis. Failure to qualify for FMLA or Colorado FMLA coverage may result in the employee not taking leave or taking leave without a legal right to return to work. Reasons for FMLA and Colorado FMLA protected leave. Employees eligible for FMLA or Colorado FMLA protected leave may take leave for specific reasons enumerated in each statute. The federal FMLA is more limited in reasons but provides the basis for FMLA family and medical leave. The federal FMLA permits leave for the birth or care of a newborn child of the employee, placement of a child for adoption or foster care with the employee, medical leave because the employee is unable to work due to a serious health condition, or to provide care for an immediate family member with a serious health condition. Federal law also extends FMLA to provide care for a military service member or veteran who has a service-related injury or illness or address a situation caused by the active service of an immediate family member. The Colorado FMLA law, the Colorado Family Care Act, applies to all of the same reasons as the federal employment law but permits medical leave to provide care to a larger realm of family members. Let's discuss the two most difficult issues in FMLA reasons for family medical leave: serious health condition and the family members covered by each statute. Serious health conditions under FMLA and Colorado Family Care Act, CFCA. A serious health condition for family medical leave involves an illness, injury, impairment, or physical or mental condition that involves a. Inpatient care in a hospital, hospice, or residential medical care facility, or b. Continuing treatment by a healthcare provider. Health conditions described by FMLA regulations for family medical leave include incapacity due to pregnancy or childbirth, a chronic serious health condition, a permanent or long-term health condition for which treatment may not be effective, treatment for an injury, a condition that would result in incapacity of more than 3 consecutive days in the absence of medical intervention or treatment. It is important to note that these definitions extend broadly to cover many health conditions, but the employee's entitlement to family medical leave under the statute must be coupled with a defined level of treatment. That includes inpatient care of at least an overnight stay or continuing treatment, either with multiple visits for treatment or a regimen prescribed for treatment. These regulations extend specific rules around the meaning and application of these terms. In situations where your employer rejects an FMLA request for leave or considers rejecting a request, you should talk to a Colorado employment lawyer about whether your leave request applies to federal and state law. Family members under the FMLA and Colorado Family Care Act. Another common source of disputes under FMLA is who the statute covers when an employee needs to provide care for a family member with a serious health condition. Under the federal statute, an employee may take family medical leave for the care of an immediate family member with a serious health condition. FMLA identifies specific individuals as an immediate family member for purposes of the statute. Under the federal law, an immediate family member includes spouse, child, parent, person who stood in loco parentis to the employee when the employee was a child, took on the responsibilities of being a parent to the employee when he or she was a child. The Colorado Family Care Act extends coverage for blood relationships, family relationships created by adoption, relationships created by legal custody, relationships created by marriage, such as stepchildren and in-laws, relationships created by civil unions, a person in a committed, live-in relationship with the employee, employer denial of FMLA and Colorado FMLA leave. It is unlawful for your employer to violate your rights to family medical leave under the Family and Medical Leave Act and the Colorado Family Care Act. An employer's failure to comply with the law or intentional retaliation for an employee exercising his or her rights can carry substantial penalty. An employee may recover lost wages, liquidated damages, attorney's fees and other relief due to a violation of the statute. Contact Denver employment attorneys about FMLA and Colorado FMLA violations. If you believe your employer violated FMLA or the Colorado Family Care Act, then you should contact Denver employment attorneys right away. An employment attorney can help you seek remedies for the employer's bad acts. In some situations, it may be possible to obtain a court order restoring you to a job or title if an employer retaliates against you for taking family medical leave. If your employer is delaying or denying FMLA leave or leave under the Colorado Family Care Act, then you should talk to Denver employment attorneys immediately about your situation.